Good afternoon, ladies and gentlemen. Happy Tuesday, February 20th. I hope you enjoyed the long weekend. You can see the agenda for today and for the week. Zoom check-ins, 3 days this week, today, Thursday, and Friday, 1:40 to 2:25, or you can check in with me by email. Please make sure you check in at least once this week. We are covering our last bit of new information today for Unit 3 on gun rights versus gun control. Your test, I will open that up today. Your test will be open up through the end of the week. A short exam. It's only about 7 questions long, as this was a shorter unit. And then on Thursday, I'll explain your final project. Your final project will be due the last week of class, the last day of class, Thursday, March 7th. So you'll have some time to get that done. But last bit of new information here. Let's get down to it. You should have finished up the documentary for today on Targeted, which was a very pro-gun, anti-gun control documentary. I mean, you can summarize the gist of that entire film, which was American democracy, American liberty is founded on our ability to arm ourselves, protect ourselves, not just from threats around us, but from government oppression. And if we were to go back and look at the question we answered last week, is it better to risk danger and death in exchange for living free? Or is it better to risk tyranny and oppression in exchange for the possibility of more safety? They very much support any sort of negative effect, or would agree to risking any sort of negative impact that stems from maximum freedom. This is not so much about gun violence and gun deaths and unwanted or preventable gun death. It has nothing to do with that. This is an issue of, can we as citizens protect ourselves to keep ourselves free from an oppressive government? And any negative consequence that comes from being armed so that we can resist government oppression is worth it. Now, I don't necessarily know if an armed American citizenry can resist the United States military. Something tells me that our shotguns and rifles and handguns aren't going to do a whole lot against, F-16 fighter jets or a trained standing military, but that's neither here nor there. It's the principle. The fact that if we have to, if we have to resist government oppression, what are we going to resist it with if we don't have anything at all? They also make the argument that the laws that we already have can't do anything to stop the unwanted, unnecessary, preventable gun violence that we have in this country. If our laws that we currently if our laws that we currently have can't stop this, what good is more laws going to do? I mean, just this weekend, 2 Burnsville police officers and a fireman were shot by a person in a home who was legally prevented from having guns. That person was not supposed to be in possession of a firearm, yet somehow that person was able to do so. Because we get to the issue of, again, what type of people break laws? Criminals. Criminals break laws. Regardless of what the law is, criminals will always break laws. So will more laws reduce gun violence? I don't know the answer to that. Last week, we talked about the District of Columbia versus Heller. And again, this is an opinion from about 15, 16 years ago now, where I talked about, Americans having a right to ordinary guns. It's no longer just about guns being necessary or related to militia service, right? The times have changed, right? This isn't the 1780s. This isn't the 1790s. It's not the 1800s. It's not even, the 1910s where people need a weapon to be a part of a militia. Supreme Court rules that you don't necessarily have to be a part of a militia or need a gun for militia service. Any sort of ordinary weapon is a constitutionally protected right, simply for defense of the home, for the defense of you, which again is a little bit different. Because if we were to go back and talk about the Miller case, it was about regulating guns that were not connected to militia service, and that the government could regulate certain types of weapons. Things have changed recently. Now, I already said the Constitution was drafted in 1787 and started to be ratified in 1789. I think the Second Amendment was ratified in 1791. A lot has changed when it comes to weapons, the technology that we have. Gaetano versus Massachusetts, which was 2016, talked about all bearable arms are protected unless dangerous and unusual. So in this particular case, Gaetano, if I'm not mistaken, was a woman in the state of Massachusetts who had gone through some domestic violence in her personal relationships. She was carrying a stun gun with her. She was carrying a stun gun with her, a taser, if you will, because she was worried about her estranged boyfriend potentially attacking her, and she wanted to be able to defend herself. Massachusetts law prohibited the carrying of stun guns or tasers. Supreme Court took up the case and said that all bearable arms are protected. They are a constitutional right unless they are dangerous and unusual. I don't know what dangerous and unusual means. Is that a bomb? Is that a nuclear weapon? Is that a grenade? Is that a rocket launcher? But bearable arms that are more or less ordinary. They're not unusual or they're not dangerous. Granting her the right to a stun gun. And this issue came up. There was some debate here because a stun gun it's not a gun. It didn't exist when the Constitution was written. They went on to say that even weapons that were not around during constitutional times, they are protected. People may possess them as long as they are not dangerous and unusual. Pretty vague there. I point that out that the Supreme Court has recognized people's rights to weapons that were not around during constitutional times because a recent Supreme Court case just from last year, New York State Rifle and Pistol Company versus Bruin, has really flipped some things on its head. All right. In New York, there was a law, basically, if you wanted a conceal and carry permit, you had to prove that you had a need for conceal and carry. You had to justify why you wanted to be able to carry a weapon around in public. Supreme Court ruled that was unconstitutional, right? They extended the Heller decision, your right to protect yourself and your home. They extended that to outside of the home. Nowhere in the Constitution, nowhere in the Second Amendment, right? A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Nowhere in there does it say that you need to prove just cause for carrying a weapon. We've already seen Supreme Court cases going back to the 1930s, right? U.S. versus Miller, District of Columbia versus Heller. The people have a right to a gun. Why do we need to prove why we need a reason to carry a gun around in public? They threw that out. But this case went a little bit further. Clarence Thomas wrote this opinion. Clarence Thomas is what we would call a strict constructionist, meaning if it's not written in the Constitution, if it is not black and white, then you shouldn't do it. The government shouldn't be able to do it. Or the people, if it's not written in the Constitution, the people don't have those rights. I give you an example, the right to privacy. Do you have a right to privacy from the United States government? Do you have a right to privacy from state governments? Do you have a right to privacy from the police? And I would imagine many of you would nod your head and say, yes, of course you have a right to privacy. Do you? If we go back and look at the Constitution, the Bill of Rights, the First Amendment talks about speech and expression, so no right to privacy there. Second Amendment says you have the right to keep and bear arms in the form of a well-regulated militia to keep the state free and independent. No right to privacy there. The Third Amendment, no soldier shall be in a time of peace quartered in any house without the consent of the owner, nor in a time of war, but in a manner to be prescribed by law. Is that a right to privacy? The fact that the government can't keep soldiers in your home? The Fourth Amendment, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Is that a right to privacy? The Fifth Amendment, no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment of indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, but in actual service in time of war or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of life and limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. Is that a right to privacy? The Sixth Amendment talks about speedy public trials. Seventh Amendment talks about juries. Eighth Amendment talks about cruel and unusual punishments. Ninth Amendment talks about the unenumerated rights. You have more than what's just listed here. And the 10th Amendment says if it's not delegated to the United States by the Constitution, the power is reserved to the states or to the people. Now, the reason we did this little exercise here is the right to privacy is a concept that came up in the 1950s and 1960s regarding women and birth control, contraceptives. Does the government have a right to police what contraceptives women are taking to control reproductive matters? Supreme Court ruled that when you think about something like the Third Amendment, no quartering of troops in your home, the Fourth Amendment, illegal searches and seizures, the Fifth Amendment, more or less the right to keep your mouth shut and not convict yourself. And additionally, the Ninth Amendment, you have more rights than are listed here. There is this concept of privacy. It's not an enumerated right, it's a substantive right, which brings me back to Clarence Thomas. Clarence Thomas is a very conservative Supreme Court justice, and right now the Supreme Court is very conservative. They have a supermajority. Many of these conservative justices are strict constructionists, meaning if it's not specifically written there, then it doesn't exist. It's substantive. It is not procedural. It's substantive. Do you have a right to privacy? Clarence Thomas would argue that no, you don't have a broad right to privacy. Clarence Thomas, because again, it doesn't say it in the Second Amendment, would argue that the only thing the Second Amendment says is that you have the right to keep and bear arms. Thus, any governmental regulation of it is unconstitutional because it doesn't say that. It doesn't say that they can regulate it. In his opinion, Clarence Thomas went on to say that any regulation of guns must have historical foundation, meaning that if it wasn't a gun law in 1791 when the Second Amendment was written, and if it wasn't a gun law in 1868 when the 14th Amendment applied the Constitution to the states, then the government has no right to limit what weapons people can keep and bear. This is problematic because 6 years prior, they said that people have more rights, people have rights to whatever weapons are available, even if it wasn't legal, even if it didn't even exist, excuse me, if it didn't exist in 1791. But then 6 years after the fact, he says that the only regulation that can exist is the regulation that was on the books when the Constitution was, when the Second Amendment was ratified or when the Constitution was expanded to the states. It seems to be a little hypocritical here. Based on this New York State rifle decision, things like background checks, gun registry, age restrictions, all of these things could potentially go out the window because unless there was a law written in 1791, unless there was a law written in 1868 in which, access to guns were limited, then all of our gun legislation could go right out the window because he is a strict constructionist judge versus, one who interprets the Constitution to ebb and flow with the time. So I don't know what's going to happen here, but this could be exceptionally problematic, especially if you are a person who supports gun control, because I can guarantee you domestic violence, mental health, terrorism, These things did not exist in 1791 and they did not exist in 1868. So any laws precluding those people from getting them, they might be right out the window. All right, that's the last bit of new information. Test is open. Take that by the end of the week. I'll explain your Unit 3 project on Thursday. And then there won't be any more videos going forward. I'll have Zooms. I'll have Zooms each day next week in case you want to check in. So there'll actually be a Zoom every day in case you need help with your project. But I'll explain the project on Wednesday. Check that Thursday this week, and then you have the rest of the time to get your individual research project done before the end of the trimester. Hope you're all doing well. I'll see you guys on Thursday this week. And until then, go Spartans.